We began the Jerry M. case because we were very concerned about what was happening with children out at the district's detention facilities, Cedar Knoll and Oak Hill. We practice there. We represent children who were detained there or committed to the custody of the city. We saw many things that concerned us.
Briefly speaking, the Jerry M. case was about how the District of Columbia 30 years ago and up until the present time, until the case closed just a few years ago, went about detaining and rehabilitating young people in the juvenile justice system.
The case was filed in 1985. It was filed at a time when, according to the public record and everything that was filed, kids who were in secure confinement were either abused, ignored, victimized, and in general, severely maltreated. It was filed at a time where the institutions that were maintained by the district were dilapidated, very, very poor physical plants.
It was a perfect storm of really horrific conditions. That was just a deplorable situation for children in the district's juvenile justice system, and quite frankly, something that the district should have been ashamed to be a part of at that time. In the nation's capital, in the richest country in the world, it's completely unacceptable that children were incarcerated in those conditions.
The Public Defender Service and the ACLU approached Covington in 2004 to join the Jerry M. case. And at the time, the government was nowhere near in compliance with the consent decree. And so we quickly assembled a team to help file a massive contempt motion and go through rapid discovery and put on a 1-week trial where we exposed a lot of the really horrific and unimaginable conditions at Oak Hill. And this included tremendous levels of abuse by the guards, selling drugs to kids, sexual abuse, physical abuse, and a lot of violence among the kids that flowed from having younger adolescents who were being housed with some of the young adults at Oak Hill. And there was also really no investment or resources being applied to meeting the needs of kids as kids. So there was no education, there was no mental health care.
Typically, in these kinds of cases, the hard and fast litigation model is used that's extremely adversarial and non-collaborative. And that had been the posture of the case for a long time. Instead, in 2004, with my appointment and this work plan model that the parties adopted and the court endorsed, the parties really embarked on a collaborative approach to problem solving and to resolving the challenges that they confronted in the case, and it worked.
Yeah, this litigation, although it took way too long to resolve, was very important to advance the reforms in the district's juvenile justice system to protect the rights of the most vulnerable citizens of the district, young incarcerated children who were disproportionately, or I would say exclusively, Black and poor from the district's most vulnerable communities, who were held in just horrific and dangerous and outrageous conditions.
The New Beginnings facility, the resources available to children in the system now are all because PDS and Covington and the ACLU didn't give up. They kept the goal in mind, and they used every resource available to them, every strategy available to them to get what they needed and get what those kids needed.
The legacy of Jerry M. goes well beyond DC. This team not only looked out for and so effectively protected the interests of DC kids, but over the course of 15 years, they developed and implemented a series of reforms that serve as a model for others around the country to follow.
Each of the organizations that were involved in Jerry M. brought tremendous depth of experience in the subject matter and in different facets of the subject matter. So the ACLU Prison Project, long-standing involvement related to conditions of confinement in secure facilities. The Public Defender Service represented class members every day and continues to, and the courts in the District of Columbia, and really knew the class itself. And Covington and Burling, and particularly lead counsel, had enormous experience in institutional reform litigation and the resources that were needed in a case like this.
What can I say about Elizabeth Alexander? She's my hero. She has devoted her entire life to fighting for incarcerated people. And all of us who do this work stand on her shoulders. Elizabeth is one of the most outstanding lawyers I've ever known. Her knowledge is encyclopedic, her judgment, her litigation skills. She is superlative in every respect, and I have learned so much from her.
Jennifer Lanoff, also an incredibly talented and smart and committed attorney. And in many ways, I'm thrilled to see Jen getting an award like this because she is your classic behind the scenes person. It's fair to say that I think Jen was the glue that held together the plaintiffs team, as well as providing a really indispensable role in communicating with government officials such as myself. And I have just a huge amount of respect and admiration and gratitude for the work that Jen did, really tireless during those times.
Alan really embodies the best values of pro bono service. He is a smart, capable, big-hearted lawyer who really goes the distance for his clients. And he really appreciates and recognizes the need to step into the breach and to help people who really need it. And Jerry M. is a terrific example of the impact of those values.
I'd like to thank the Public Defender Service for its decades-long pursuit of justice in Jerry M. Also want to thank the ACLU National Prison Project, Covington and Burling, and others for their incredible work.
From the bottom of my heart, I want to say thank you to the heroic lawyers who litigated the Jerry M. case. This was a historic and groundbreaking and life-saving piece of litigation that would not have happened without the efforts of those who are being honored tonight. So congratulations and thank you again.